Non-practicing entities accounted for roughly 90% of all 2025 high-technology patent litigation, making a freedom to operate analysis performed once before launch and then forgotten a seriously dangerous habit in 2026. In 2026, it is close to reckless because non-practicing entities accounted for roughly 90% of all patent litigation in the high-technology sector in 2025, and 9 of the 10 most active patent plaintiffs in United States courts that year were entities that build no products and sell no services, only patents and the settlement pressure those patents generate. A freedom to operate opinion performed once at product launch and never revisited does not protect a company against a feature shipped 18 months later, and 18 months is roughly the pace at which most technology companies now ship material new functionality. A proper freedom to operate analysis is a specific and disciplined methodology, not a general patent search. It begins with a technical breakdown of the product into its constituent functional features and mechanisms, drawing on internal engineering documents, product specifications, and architecture diagrams rather than marketing descriptions of what the product does. It continues with jurisdictional scoping, because patent rights are territorial, and an opinion covering the United States says nothing about exposure in the European Union or any other market where the company intends to make, use, or sell the product. It concludes with a search window calibrated to actual patent life, which is longer than most founders assume. A United States patent term extension can add up to 5 years beyond the standard 20-year term, and a European Supplementary Protection Certificate performs a similar function, which means a search limited to patents filed within the last 20 years will systematically miss patents that are still enforceable today. Cost has historically been the barrier that kept startups from commissioning a proper freedom to operate opinion before every material launch. A deep, multi-jurisdiction investigation performed by attorneys using traditional manual search and analysis methods has run from $20,000 to $50,000, a number that makes sense for a company preparing a Series C round or a major product launch, but is difficult to justify for every incremental feature a fast-moving engineering team ships. That calculus is changing. Artificial intelligence-assisted search platforms, using semantic matching and graph-based representations of patent claims rather than brutal keyword search, are reported to cut project time by as much as 80% in some engagements and to reduce cost by $20,000 to $30,000 per claim chart relative to a fully manual process. The honest characterization of where this technology stands in 2026 is that it functions well as a first-pass triage tool, surfacing candidate patents that a keyword search would miss because it can match concepts described in different terminology, but it remains a poor substitute for attorney judgment on the harder questions of claim construction and infringement analysis that actually determine legal risk. That gap between artificial intelligence-assisted search and attorney judgment matters most in the fastest-moving area of current patent risk: agentic artificial intelligence systems. Large technology companies have filed aggressively in the area of agentic orchestration, the methods by which an artificial intelligence agent plans, evaluates, and executes multi-step tasks without constant human direction. Counsel tracking this space describe agentic orchestration as the highest risk category for startups building agent-based products in 2026, precisely because the functional building blocks, task decomposition, tool selection, and iterative evaluation of intermediate results are generic enough that a single patent covering the general method can plausibly read on many different specific implementations. A startup shipping an agentic feature without a freedom to operate analysis covering this specific claim category is making a bet it may not know it is making. The litigation record from the last year illustrates that this risk is not theoretical. In June 2026, AI Law filed a patent infringement suit in the United States District Court for the Northern District of California against Eve Legal and its corporate parent, Butler Labs Incorporated, alleging that Eve Legal's artificial intelligence-assisted document drafting product infringed patents covering methods for converting unstructured material into long-form, properly formatted documents using artificial intelligence. Whatever the eventual outcome, the suit illustrates a pattern that is becoming common. A company builds and ships a plausible, useful artificial intelligence feature, and a rights holder with an earlier filed patent covering a generically described version of the same method asserts infringement after the product has meaningful market traction and real revenue at stake. The average cost of defending a complex artificial intelligence patent infringement suit in United States federal court now exceeds $3.5 million, a figure that dwarfs the cost of even the most thorough freedom to operate opinion performed before launch. Startups often assume that because they built their own technology independently, without copying anyone, they cannot be liable for patent infringement. That assumption reflects a common but consequential misunderstanding of patent law. Patent infringement does not require copying. It requires only that the accused product practices the claimed invention, regardless of whether the accused infringer ever saw the patent or the patented product, and regardless of how much truly independent engineering work went into building the accused feature. A team that built an agentic orchestration layer entirely from first principles, never having heard of a competitor's patent, can still infringe that patent the moment the shipped feature practices its claims. This is precisely why freedom to operate analysis exists as a distinct discipline from ordinary product development diligence. It answers a question that good engineering alone cannot answer, because good engineering tells you whether your code works, not whether someone else's patent claims cover what your code does. Here is the unexpected implication for startups building AI-native products in 2026. The conventional wisdom holds that smaller companies are lower value, lower visibility targets that patent assertion entities and larger competitors will not bother pursuing. That logic runs backward for the technology sector specifically, where studies have found that patent assertion activity disproportionately targets smaller companies precisely because they lack the litigation budget to mount a prolonged defense and are therefore more likely to settle quickly on terms favorable to the patent holder. Being small is not protection. It is, in the current non-practicing entity litigation environment, closer to a target profile. A startup's freedom to operate analysis should therefore be sized to its actual risk exposure, which for a fast-growing technology company shipping agentic or other AI-native features is higher than its balance sheet or headcount would suggest. The practical framework that is emerging among sophisticated general counsel is tiered rather than binary. Rather than treating freedom to operate analysis as either a full $50,000 investigation or nothing at all, companies are commissioning artificial intelligence-assisted first-pass searches on every material feature before launch, reserving full attorney-led opinions for the highest risk components and the core jurisdictions where the company actually generates revenue. This tiered approach allows a company to maintain continuous freedom to operate coverage across its shipping roadmap, rather than a single point-in-time snapshot performed before the company's most recent major launch and never updated as the product evolved. Given that most technology companies now ship material new functionality every 12 to 18 months, a freedom to operate practice that only activates once, at initial launch, is functionally providing no coverage at all for the majority of a company's product lifecycle. Search tools available through the United States Patent and Trademark Office, including the Patent Public Search Platform, give any founder or in-house counsel a starting point for a preliminary landscape review, but they are not a substitute for a formal opinion. And treating a do-it-yourself search as equivalent to a freedom to operate opinion is itself a source of risk. A formal written opinion, prepared by counsel and covering specific claims against a specific product implementation, carries legal significance that an informal internal search does not. It can support a defense against a claim of willful infringement, which matters because a finding of willfulness exposes a defendant to enhanced damages of up to 3 times the amount otherwise awarded. A company that never obtained a formal opinion, relying instead on an engineer's informal search of public patent databases, has no comparable defense available if litigation follows, regardless of how thorough that informal search actually was. Timing the freedom to operate analysis correctly within the product development cycle also matters more than most engineering organizations assume. An analysis performed after a feature has already shipped identifies risks the company can no longer avoid without a costly redesign, a licensing negotiation conducted from a position of weakness, or continued exposure to a claim the company now knows exists. An analysis performed during the design phase, while the engineering team still has latitude to route around a problematic claim through an alternative technical implementation, converts what would otherwise be litigation risk into an ordinary design constraint, no different from a performance requirement or a security specification. The cost difference between these two timings is not incremental. It is the difference between a design review conversation and a seven-figure litigation defense budget. The tiered budgeting approach that sophisticated general counsel now favor extends naturally to this timing question. Cheap, fast, artificial intelligence-assisted searches performed early and often during design catch the majority of avoidable risk at minimal cost, while full attorney-led opinions reserved for the highest risk components and the jurisdictions generating the most revenue provide the litigation-grade documentation a company actually needs if a dispute ultimately arises. Companies that skip the cheap early search and rely solely on an expensive opinion performed once before launch are optimizing for the wrong variable, spending real money on documentation quality while missing the recurring, low-cost opportunity to design around risk before it becomes fixed in shipped code. The startups that will avoid becoming the next AI, Law v. Eve Legal, are not the ones with the best patent lawyers on retainer. They are the ones that have built freedom to operate analysis into the engineering release cycle itself, treating it the way mature companies treat security review, a recurring gate before ship, not a one-time compliance exercise performed under duress after a demand letter arrives. Interested in analysis about the intersection of corporate law, securities regulation, tech, artificial intelligence, public policy, and the law? Check out my Substack channel, https://theinnovationattorney.substack.com.